Case that we're going to call on the docket is going to be U.S. Bank Trust versus Patricia Marie Koza Lee, also known as Patricia Lee, also known as Patricia Lee. Patricia M. Lee, also known as Patricia Lee.
I know her as Patricia Lee.
Okay. I know her as Pat. If I knew her, I'd know her as Pat. That's what her friends call her.
Morning, and may it please the court. My name is Ron Gachet. My law firm, Shapiro, Fishman, and Gachet. We represent the appellant and the plaintiff below, U.S. Bank Trust. 5 minutes will be fine for rebuttal, Your Honor. This case should be and should have been what is, I consider, a garden variety foreclosure action. Now, in some of our appeals as litigants and as jurists, the record sometimes comes to us cluttered. Sometimes we're not really sure what the trial judge was thinking, why a judge makes a particular ruling. Fortunately for us and for you as the panel, in this particular case, Judge Davidson laid out exactly why she ruled for the defendant borrower in this particular action.
So you want to teach her a lesson for doing that?
No, I think it's great that she did. Unfortunately, she erred, but she gave us a perfect roadmap of why she ruled the way she did.
She was half right, in your view,
Half right for...
on the statute of limitations.
Well, she got both issues wrong, unfortunately, Your Honor, because even if she was half right, I wouldn't be up here. I would have been conceding that I didn't have any grounds to be appealing. So let me take you through just what happened at the trial, because I think it's pretty easy once we get on track as to what happened at the trial level.
If it's of any help to you, we actually do read the briefs.
I know. It's more for my benefit if it's okay with you, since I have so much time and I'm not going to need it all.
Okay. It's your time.
So essentially, the plaintiff puts on a full foreclosure case. Let's be clear about that. All the documents come into evidence, the note, the mortgage, default letter, testimony is fine. The only issue that the defense argued at the time was that the paragraph 22 default letter did not comply, and the reason it didn't comply is because it contained two inappropriate components. So let's be clear.
What's the purpose of the paragraph 22 letter?
Well, it puts the defendant or borrower on notice that in 30 days we have the right to accelerate your loan and to file suit for the entire indebtedness. So that paragraph 22 letter...
Unless what?
Unless
You pay the money that's in the letter.
Well, right. If you reinstate, then that's fine. You have 30 days, and you can actually always reinstate any time up until judgment if you want. So in this particular case, paragraph 22 has certain dictates, and it says this is how the letter has to read. Let's make no mistake. The default letter reads perfectly. The problem the trial judge and the borrower had is that the amount that they say you need to reinstate was incorrect. But the form of the letter, and sometimes we had letters in the old days, in the older cases, where the letters were defective. This letter's not defective. The issue is the $86,000 figure that's in the letter, is it correct? Or if it's not correct, does the letter still substantially comply? Because that is the standard when we're talking about a condition preceding. Now, in this particular case, counsel argued there were two components that were wrong in the $86,000 figure. Let me dispatch and dispose of the first one, which is the claim that some of it included what he calls time-barred debt. There is no such thing anymore after this court's decision in Grant, after the third and the second and the fourth all held and have adopted Judge Lawson's concurring opinion in Bollettieri, that is, that there is no such amount that's more than 5 years, less than 5 years, that a bank can pursue in the foreclosure action. There's no time-barred amount. In the event that you have an installment note like this, any amount that's past due upon acceleration
But at
can
the
be
time of
sought.
trial, it was probably a fair argument because we had that Veldin decision.
No question about it. Veldin
It's
was,
that very, very wise concurring opinion in Veldin. Veldin was,
Veldin was in January of 18, and Grant was almost a year later in December of 18. But make no mistake, Grant is the law now, and the other courts have all come on board. And I think we're all in agreement that that argument I shouldn't have to spend much time on unless I'm confused about it. There is no more time-barred debt, and I would assume my opponent is going to concede that at this particular point, albeit that it was an argument to be made at the time. So if there's no such thing as time-barred debt, and a bank can seek any amount going back as far as the borrower wanted to have been in default, and this borrower has been in default since 2010, so let's be clear, and she hasn't made a payment in close to 9 years, what we're left with then is what appeared to be attorney's fees from a prior foreclosure case. Now, I have two arguments against why that's completely inappropriate to make an argument at the trial level that those fees somehow render the demand letter defective. First off, there was no testimony about a prior case. There just simply wasn't. The defense tried to inject it, but it wasn't in the pleadings, it wasn't in the testimony, and in fact, Ms. Macias from my office made clear that she continued to say, I'm not trying by consent any issue related to, quote, another case. You won't see a case number referenced in the transcript anywhere. You won't see an actual case discussed. All you'll hear is that there must have been another case because in the amount of the sum needed to reinstate, there are fees and costs. And yes, there was a prior action. The only way one can know that there was a prior action with a ruling adverse to the bank where fees and costs were somehow incurred is if the trial judge did the research on her own. And as we all know, that would be a violation of the bank's due process rights if you're going to have the trial judge out there researching his or her own inquiries or uncertainties. So if this trial judge, Judge Davidson, decided
Ms.
to
Lee testify that there was a prior foreclosure action that had been dismissed?
Who?
Ms. Lee?
She may have testified to one, but there was no evidence put in the record.
What is testimony?
Well, I understand that testimony is is evidence, but there's nothing for the court to base that on. There was no judicial notice of how it ended. There was no issue of what the
Didn't
issues.
she testify that it was, they sued me before and it was dismissed?
No, I don't know that she actually said they sued me before and it was dismissed. She may have testified that there was a prior action or they brought a prior suit. But even if it was dismissed, we don't know why. And it's not a prevailing party issue. We're not talking about...
If it's dismissed, it's because the lender lost. I mean, right?
You can presume the lender lost.
How else can you read it other than the lender lost? If
The lender may-
lender's suing the borrower and the case is dismissed, the lender lost.
Lender takes a voluntary dismissal.
Okay.
That lender didn't lose.
Which, if the lender takes a voluntary dismissal, if you're talking about is that a favorable outcome to the borrower, don't the cases say yes?
But we're not talking about favorable.
Answer my question.
It's a favorable outcome for the borrower because the bank took a dismissal.
Okay, so if there was testimony that the bank sued me before and it was dismissed, that doesn't mean that Judge Davison went and got her magnifying glass and Sherlock Holmes hat and started trying to figure out what happened, does it? I mean, that's evidence of record that the case was brought and dismissed, right?
But that's all that is. What do you do with
So
that?
there was no evidence.
Well, I'm saying that there was nothing to establish that fees and costs were incurred, that those are the fees and costs that were in the reinstatement amount. Everybody's jumping to conclusions.
Well,
that-
aren't you going down an unnecessary rabbit hole here? I mean, basically, if she said, we had a prior lawsuit, that case was dismissed, we incurred $10,000 in fees in that prior suit, we're now trying to collect that as part of our collection of this debt. Isn't that what this is about? So, I mean, Judge Edwards making good points, and you're fighting unnecessarily instead of just agreeing with what the obvious that he's saying.
Well, as I indicated...
No, that's not your point, though. Your point is there's a $10,000 fee that was incurred in the collection of this debt, and that's why it was added on to your paragraph 22 letter, and that's why I got the 86 grand, and that's why we sent it.
You don't have to be a prevailing party on the
Yeah, we
mortgage.
get it. Yeah, I mean,
Right?
but
Well, you're making that, yeah. Well, I started by saying there's two arguments, but I don't want to concede that there was enough in the record for them to make that determination of exactly what those fees were for. But I will pivot to my second argument, which is
they concede. I mean, that's what I guess we're not getting it because up here is the judge says, well, that 10 grand must have been what was paid to the borrower when they won the first foreclosure because the bank dismissed, and your colleague, your opponent, professionally concedes that's not right.
Correct.
Okay, that's to your benefit.
Correct. And
So you're fussing away with us about stuff that's kind of your meter's running here.
No. I thought we're all in agreement in this room that it had nothing to do with any money the bank paid the borrower. That didn't happen. These are, if anything, and the implication would be that these were the bank's own fees in prosecuting its own earlier foreclosure action.
And let's say it was.
And let's say it was. So let's
Okay.
pivot to my second argument and the more compelling argument,
And Green
which
kinda
is the loan documents
Yeah,
give me the right to
okay.
collect that money, right? The loan documents give me the right to collect that money, whether I win or not. And that's really the issue. But again, Judge Edwards, I just want to make clear that I just didn't think there was enough to establish what that amount was, what those fees were exactly for. But even if they were, worst case scenario for me, they were my legal fees for a foreclosure that was, let's say, involuntarily dismissed because I lost on all of the merits. Okay, that'd be the worst holding possible. We don't know that because there's no record evidence of what happened in the other case. But let's just assume the worst. Even in that situation, paragraph 14 of the mortgage, and there's a paragraph in the note that says any amount that I incur or expend in the face of a default, and let's be clear, the borrower has never disputed that she has been in default since 2010. And the mortgage documents give us the right to add those fees and costs, whether we prevail or not, to the debt. And when the borrower asks for a reinstatement amount, we are entitled to give her that reinstatement amount. And we cite in our brief multiple cases from around the state, the Seimer case, the Rockwood case, the MAW case, and the Savarese case, which all say that if a lender sues for foreclosure, and for whatever reason the court denies foreclosure, the lender can still recover its attorney's fees as long as there was an established default.
What if the lender wasn't the one that paid the fees in the first instance? Let's say you're the third assignee of the debt and the first foreclosure action 8 years ago, some other bank or servicing entity was the one that paid the fees. And
The current bank steps into the shoes of the predecessors by assignment, and she doesn't just get relieved of all the prior debt, interest, taxes, everything that was advanced by a prior lender simply because the loan is sold. That would be a windfall for the borrower, which is found nowhere in our case law or nowhere in our jurisprudence. So we are an assignee. And if we're an assignee and we bought that debt for value, presumably, which is how assignments typically work in the mortgage foreclosure world or in the commercial paper world, then we bought that debt. We bought all of it. And that debt is her debt. And all we're doing is saying in the letter, you owe $86,000. Now let's be clear. We're talking, I think it was about $10,000 that he's claiming in legal fees and costs, which again, we don't know why they were incurred. We don't know what the facts of that other case were. All we know, as Judge Edwards says, is there was some favorable ruling for the borrower. Well, all of the cases that I cite in my brief, there was a favorable ruling of no foreclosure, but attorney's fees were still awarded because that's the way the loan documents are written, and that's a contract that can't be altered by the trial judge or by the appellate court because that's a contract between two parties. And so in this particular case, all of this is of no moment because the demand letter simply states that you owe that money. To claim that you don't owe that money, maybe at that point you bring your own action, maybe you bring your own claim to seek to collect it back, but you offer something. You certainly, if you're going to argue that you're prejudiced by that demand letter, you make a tender. A lot of our case law talks about tender. It talks about the fact, well, did you try to cure the default with the amount that you thought you owed? If you didn't think you owed the $10,000, or if you didn't think you owed the $12,000 of, quote, time-barred debt, which again was an estimate by counsel, well, where's the rest of the tender of what you did owe?
so your view then is the $64,000 of the $86,000, I'm rounding the numbers, if your opponent would have a better argument if there was some tender of at least $64,000 to say, I agree that I owe 64 in unpaid, mortgage payments for X number of years, but I don't think I should owe under Veldin or the attorney fees, and here's my 64 you need to reinstate.
And you know what?
Then we'd have an argument about prejudice, whether the number's right.
Right, because we all know that for a condition precedent, let's not lose sight of the path we're on. We're here for quote-unquote failure of a condition precedent. We're not here because I sent you a bill that was too high, or we're not here because of an unfair, deceptive trade practice of some sort. We're here because he says that we failed a condition precedent, and the judge in her ruling, she says, the court finds in favor of the defendant due to a violation of condition 22 of the mortgage. That's the ruling that was being appealed. There's no violation of condition 22. The letter was sent. It's not a violation to have in it an amount that might be more than what you think is necessary to reinstate. And if for some reason it is a failure as opposed to a violation of a condition precedent, then we have to have prejudice. And how was she prejudiced? How was she prejudiced if she didn't offer up the remainder of the money if she didn't have it? So again, we stand firmly on our position that we are allowed to include fees, costs, anything to protect the security interest that we have. The time bar debt certainly shouldn't be an issue, and I'll use the remainder of my time for rebuttal. Thank you.
Thank you, Your Honors. May it please the Court. Bo Bowen, Bowen Law Group, on behalf of Patricia Lee. I want to make a few comments. I would almost concede the issue on the statute of limitations. I do want to address towards the end of my time, just make a couple arguments on it, because as I believe, I don't remember if it was this court's case in Grant or the Strum case, where it was really uncontested, and that's where the result came from. I think the homeowner in that case didn't even file an answer
What do
brief.
you mean you want to address the statute of limitation? You mean about monies owed more than 5 years?
Yes, Your Honor.
Okay.
And I'll say that for the end, because I think, from where this is going, I think the more pertinent issue right now is the attorney's fees that were being added into the notice of default. Opposing counsel cites some cases that state where the bank is allowed to collect their attorney's fees even if they lost a prior foreclosure, so that they're allowed to assert that in their notice of default. The reason why that's not meritorious is, if you'll notice, the cases that they cite are all pre-1988 contracts. Why that's relevant? We have a reciprocity statute, 57105, paragraph 7, which is what our attorney's fees are claimed under. The reciprocity statute is what gives the homeowner the right to collect fees when a contractual provision gives it to one party. That reciprocity statute also makes it a prevailing party entitlement. They're arguing that they weren't a prevailing party. It doesn't matter if they weren't a prevailing party in the last case, they're still allowed to collect their fees. But with the reciprocity statute, it now becomes a prevailing party attorney's fee award. What they're arguing is, if the last case was dismissed, the homeowner's allowed to collect their fees from the bank pursuant to reciprocity statute, but they're also allowed to collect their fees from the homeowner? That makes absolutely no sense. Those cases that they cite are all pre-1988. The reciprocity statute took care of that and said, no, it's the person who's allowed to collect those fees is the prevailing party. The homeowner in this case is the prevailing party in that prior case. She was the one who was allowed to collect her fees. Now, we're not suggesting that there's any evidence that the prior bank paid her fees, but they are certainly not allowed to collect their fees in a case that they lost because of 57105.
So you're saying 57105 then modifies the contract between the parties?
Absolutely, Your Honor.
And what case says that?
No case says that, but there's plenty of cases out there that talk about 57105 being a reciprocity statute and being for prevailing
I know
parties.
a lot of those cases, but I'm just saying, what case says under 57105 we're going to go back and modify what's in the mortgage?
I don't have a case that says that, and those direct terms that you're asking for, I don't have a case that says that.
I understand what you're saying. It does kind of seem a little odd that you can file suit and lose and still be entitled to your money, but your client agreed to it.
She also, her agreement doesn't override the statute either. When you enter into an agreement with somebody, and this contract says, talks about complying with state law, and they're allowed to collect fees as long as it's compliant with state law.
57105 gives your client rights.
Correct.
It doesn't, I don't see anything in there that it takes away from the bank's right to collect. Again, I understand there's some logical issues there, but in terms of the law, which unfortunately is not always logical, I just don't see where 57105, erases that right from the bank. I mean, if it were a prevailing party standard, I get it, but that's not what it is.
But I disagree with you, Your Honor, that it is a prevailing party standard because the statute itself says that the prevailing party is entitled. That is the party that prevails is entitled to collect
Let's
those
say
fees.
that you've got monies that the bank had to pay to her for her fees. And then you've got fees that the bank incurred to pay for their own legal fees. We don't know, first of all, do we even know that the $10,000 were attorney's fees?
Yes, Your Honor, there's testimony, it's attorney fees, court costs, and other things associated with the prior foreclosure. And I can refer, Your Honor, to the transcript. I don't have the record number, but the transcript page is 116 through 122. Trial counsel Joseph Colombo did a pretty good job. The witness in this case for the bank took, I think, about 2 hours to go through the payment history so she could determine the amounts that are due and owing that were asserted in the notice of default, so she can itemize it out.
All right, let's assume for the sake of discussion that there is, record evidence. Did the $10,000 then include monies both monies that the bank had paid for her fees, or did it just include monies that the bank paid for their own fees?
It wasn't specified.
So for all we know,
It was just for the attorney's
bank
fees.
paid her fees, and only under the terms of the contract are suing for their own fees.
Correct, Your Honor.
Okay.
And my argument, first off, to address Judge Edwards' question, no, there is no case law directly on point, and I'm hoping I get one here in this court. And it's just based on reason. We have to look at the law and apply rational thought, apply reasoning to it, and logic. And if the statute is, if going back to your statement about the law is not always logical, well, that's this court's ability to make it logical. We have a situation where we have a reciprocity statute. What's the purpose of the reciprocity statute? To give prevailing party fees to the other person in the contract.
And they did that. They paid her fees.
What's that?
They paid her fees. Let's assume that, that occurred. They paid her fees, and they're not seeking to recoup those fees. They're only seeking to recoup the monies that they expended for their own fees in the attempt to foreclose upon a property that your client hasn't paid apparently a dime on for 9 years.
I would say that would be an illogical result, and that's why I'd ask this court not to take that position. The reason why, and I want to go back to the purpose of the reciprocity statute, is to even the playing field.
Remember, you're only talking here about the letter. You're only talking, whether the bank can ultimately collect those amounts, might be determined at a later point in time. But here, all you're talking about is whether there was compliance with the provision of the contract that said the Rule 22 letter.
I don't think you can separate those two. If they're ultimately not able to collect it later, then they shouldn't have put it in the notice of default. Because think of the purpose of the notice of default is to inform the homeowner that this is what you have to pay to reinstate your mortgage and get back on track.
And then how do you establish prejudice?
I'm sorry?
How do you establish prejudice?
Well, I think on the face of it, if somebody's asking $10,000 in addition, I'll answer this question for you.
Client tender any monies?
She sought to get refinanced and wasn't able to do so because of the foreclosure action.
Okay, but
she would have had a co-signer.
But there's no evidence that it had anything to do with the $10,000, did it?
Yes, she testified that was one of the reasons why she wasn't. She had a brother that was willing to co-sign on the loan to get this debt.
So her brother would have said, let's walk through. I know you want to say this to the end. I mean, it seems pretty clear under our recent case, post-Veldon, that the inclusion of the $12,000 is accurate.
Based on that law, yes. And
Okay,
if I have time, I'll argue against that, but yes.
Well, you probably should use your time more effectively than arguing against an en banc decision that we issued earlier this year.
I understand.
But you do what you want. I mean, in essence, we're talking about, you're saying to us vis-a-vis your response to Judge Cohen's prejudice argument is that your lady could have paid the 76, but she couldn't get to the 86 because the brother wouldn't co-sign or something?
Well, there was two things. I know in retrospect, we're allowed to look back and say the statute of limitations doesn't apply to borrow that debt, but at the time, she was looking at a $22,000 addition on top of what might have actually been owed. One of the problems, one of the prejudices in this notice itself is it's not like they itemized that amount, so she can say, oh, look, part of this is for attorney's fees, part of this is for borrowed debt, so I can figure out what I should or shouldn't know, and then tender a payment to the bank.
Did she ask for itemization?
I think at one point they asked for reinstatement figures, but I don't know if she specifically asked for an itemization. But think about the burden you'd be placing on the homeowner to figure that out on their own. Paragraph 22 it puts that burden on the bank to notify the homeowner what's owed, not for the homeowner to then figure it out on their own when the notice states too much.
And the bank apparently said we did. That's the number. So now the burden is back on the homeowner to say, well, wait a minute, you got the numbers wrong. We need to talk about this, right?
Or she can challenge it in court. It's her right to challenge it in court, which she did. And if we're going to say that if she successfully challenges it in court, she still loses because she didn't call them ahead of time, because the bank wasn't clear on how much was owed, because they buried that amount.
They were clear as to how much was owed, though. I mean,
they were clear as to how much was owed, but they were wrong in the amount that was owed. And if we're going to place the burden on her to figure this out of court without an attorney against a bank who has far more sophistication than her, rather than exercising her right to go on court and challenge this, I think it's an unfair burden to put on the court. There's a reason why we have paragraph 22, so we don't get to the court stage. So she knows exactly what is owed and what is legally required to cure her debt so she can reinstate her mortgage. By conditioning reinstatement on an amount she didn't owe, saying you're not allowed to reinstate unless you pay this amount.
Under the contract, she did owe it. That's the point I think that Judge Edwards was making, is that pursuant to the terms of the contract, those were funds that were owed.
But you have to read the contract in conjunction with the laws that existed at the time when they entered into the contract. They weren't entitled to collect that because the reciprocity statute makes it a prevailing party award. They were not a prevailing party.
I understand your argument, but I mean, it's not like the bank was committing fraud and asking for things they had no right to. They had a contract, following the contract, here's what you owe. Now let me ask you this, changing just a little bit here. She couldn't come up with the 10 grand extra for the attorney's fees. Could she have come up with the 12 grand extra that by now the law says she really did owe?
I'm sorry?
In other words, you said she was prejudiced because the letter wasn't accurate according to her, because it had 22,000 extra. 10 round numbers for attorney's fees and foreclosure cost, 12 for the time barred debt. Was there any testimony that she could have come up with the 12? The 10 was what broke the camel's back?
There's testimony that she could have possibly refinanced this. And I want you to think in a practical term. Everyone here has gone in for a mortgage. I assume someone has gone in for a mortgage, they're going to do a credit check. It is much more likely to get a refinance with your brother, whoever it is, co-sign on this when you're not in a foreclosure action, as opposed to like
9 years to refinance it and couldn't get it done in 9 years.
I'm sorry?
She had 9 years to refinance this debt. And all of a sudden, it became doable for her.
Well, I would say
is that your argument?
I would say it's unfair. I think that's an unfair characterization by going back that far and saying somehow she was negligent. You got to remember, for like 5 years of this, she was in a foreclosure action, so she couldn't, in a prior foreclosure action, so she wouldn't be able to refinance during that period. And she, by the way, won that case. So to put a burden on her to say that it was a long period of time, that's not the full picture. There was a prior foreclosure. She defended, she won. She testified in this at all times. She's been trying to resolve this. She even was going into testimony about how she was trying to resolve it for the bank, and the bank objected any testimony about her resolution. Like, it's irrelevant that what she did to try to resolve this debt. And the court sustained that objection, so she wasn't even allowed to testify to what she's tried to do to resolve this debt. At the time this case was filed, the only option she had was to pay an amount of their attorney's fees that I would argue today was not owed. And absent paying that, they're going to be able to foreclose. And then there was an argument earlier about maybe she should tender payment. And well, let's say she only owed $64,000. Did she attempt to pay that $64,000? You can't do that because the mortgage contract states they're allowed to accept less than the overall balance and still foreclose on you. So if she thought she only owed $64,000 and sent $64,000 to them, the bank could cash that and still foreclose on her because they think she still owes more money. And now she's stuck in a foreclosure action. If you just if she got the trial and the trial court said, you know what, yeah, there was $10,000 in here that you weren't allowed to charge to her, I'm just going to redact a judgment and exclude that out. Well, now you've still violated the homeowner's right to reinstate, because the right to reinstate ends upon entry of judgment. So they send her a notice of default that says, you need to pay $10,000. That was our attorney's fees, even though you won the last case. Pay that now, or we're going to foreclose. And even if at the end you win on this foreclosure, we're still getting judgment against you just for $10,000 less, and you can't reinstate now. That's unfair. It's not what paragraph 22 is about. It's not what the reciprocity statute was about. And to allow the bank to say, yes, we won or we lost the prior case, and as you noted earlier, the court say even if it's a voluntary dismissal, the homeowner is still the prevailing party entitled to their fees. What kind of system are we going to have where the homeowner can win a case?
Fair to the bank that she's in a residence for 9 years without making a mortgage payment?
I'm sorry, Your Honor?
Is it fair to the bank that she's in a home for 9 years without making a mortgage payment?
It's fair that they had the right to go to court and assert their legal rights and that they
Answer is
lost.
yes.
I'm sorry?
Your answer is yes.
I think it's fair that, yes, she's in this home because, and I would address that, if this dismissal stands, as we all know, she's not getting this house for free. She's still going to have to go in and make, the debt's not gone. The mortgage isn't gone. She's still going to have to make her mortgage payments to keep this home. So you're not ruling here. If you rule in favor of...
She hasn't. She hasn't had to make a mortgage payment in 9 years.
But again, Your Honor...
That's worth a lot.
It's worth a lot, but that doesn't negate her rights under the mortgage to have a notice of what's actually owed. It doesn't say, okay, well, you didn't pay your mortgage, therefore the bank's allowed to assert fees they don't owe. You don't owe them. That's not fair, especially when part of that time you're talking about was a prior foreclosure action that was wrongfully filed for whatever reason because she won it. You can't hold that period of time. You can't hold it against her. She has doing it's a testimony that she's been trying to get this thing a little modified. Everyone knows that if you wanted to go on a refinance loan to get to somebody else because the relationship with this bank is soured, nothing's going on, you want to refinance with someone else and get this paid off, which resolves everybody's issue, you're going to have a hard time doing that when you're in a foreclosure. No bank's going to touch you, and she testified to that. Had they not foreclosed on her, had they given her the correct notice with the correct amount, she may be able to go on and refinance that amount. So
Did she ever contact the lender at all to say, I think these numbers are wrong?
Your Honor, I don't know specifically the answer to that question. I know she spoke with her counsel, and it was her counsel that kind of helped go through this and figure out that something was wrong. Then what transpired during the case, obviously there's...
That's why I'm just trying to figure out, I mean, short of an actual tender of sending a certified check, you can do less things and go, I don't think I owe you the 10 grand. Where do you come up with, or how do you come up with this $87,000 or whatever it is? How do you come up with a number that doesn't match what I think I owe you? I didn't really see that in the record.
I don't know that there wasn't either, Your Honor, if she called that. And I would say, although I appreciate that question, I think switching the burden over to the homeowner, I don't think that was the intent in paragraph 22.
Let's make it more dynamic here. Let's say instead of being however many years behind, she was 2 months behind. And so she says, all right, I know I'm going to get a letter that says I owe 2 months back payments, so $2,000, and she gets a letter that says $86,000. You'd think that would, regardless of the burden or, I'm the borrower and I'm not the big bank, that would trigger a response saying, I know that I'm 2 months, I'm $2,000, how did you give me a letter for 86? It must be wrong. I can make arrangements with my mother to get the $2,000 back plus interest, et cetera, but explain to me the 86. Now, if she doesn't do that, why isn't that problematic? You're making it sound like it's unfair that when you get a letter that you should respond to it and say, hey.
I appreciate that question.
Thanks.
If this was the first foreclosure action, maybe. She's been through this before. Her response that she did do was to contact her attorney, and I don't think anyone's going to suggest that she's not able to do that. She contacted her attorney.
Did the attorney then contact bank and say, hey, your numbers are way off? Let's use my example again. I'm representing this lady here, and she got a letter from you that says 86 grand. She thinks she's 2 months behind. There's no prior foreclosure actions, et cetera, et cetera. Did you send the wrong letter did you mean it to send it to person X as opposed to my lady, or what's up? Wouldn't that be a normal response, a fair response, and that would then go to the issue of prejudice at some point?
Sure, Your Honor, but she wasn't allowed to testify to the efforts that she took to resolve this after the foreclosure.
Cross appeal that?
I'm sorry?
Did you cross appeal that?
No, I mean, it wasn't,
I mean, we know you won, but I mean, if you see the tea leaves that might be coming down here and say, okay, look, if, the failure to show prejudice regarding the Condition 22 letter, we need to get this on the books with the appellate court too to say, you can't hold it against us because we tried to show that we were prejudiced and we weren't allowed to testify to that.
I understand, Your Honor, but what I think the court needs to keep in mind on this is these are all great factual questions, but the court made a factual determination on this and found that the including $10,000 or the $10,000 additional was a material insufficiency. The trial court is the one that was...
Based on no evidence, apparently.
No, it was actually based on evidence, based on the testimony before the court that there was a prior foreclosure and a dismissal, and even the bank's own witness testified there was a prior action, a foreclosure action, $10,000 worth of fees, costs.
But her inclusion of the judge's finding that 10 grand was material was also coupled with her finding that that was actually 10 grand that was paid by the bank to your client as the winner in that case, which you concede is not supported by any evidence in the record.
She did misstate that portion, but I don't think that changes the materiality of what $10,000...
Well, I don't know.
It does.
I think it does, but...
Well, the issue is this $10,000 material, not where it came from. The $10,000 is material, and that's what the court found was immaterial. And I don't think this court's in a position, based on your own precedent, to overturn the trial court's decision of fact. Even if you would have come to a different decision, her finding of fact is entitled to a presumption. What I want to mention on the statute of limitations argument, it's just going to be really brief. I'm not going to go into the substance and the merits of it. And I think it was the Strum case that referred it back to the trial court for a new trial. I think if this court were to find that obviously the statute of limitations argument doesn't work because it changed during this briefing, the proper remedy would be to send it back for a new trial. The reason why is at the time of trial, we did have cases in favor of that statute of limitations defense. Trial counsel presented its case and prepared trial strategy based on the law at the time. To now change it at this stage, it even changed during this appeal after we filed our answer brief. It would be like changing the baseball game, bottom of the ninth inning, and then saying in favor of the home team. I think that's why the Strum case referred it back.
What do we get by remanding it for a new trial? For what reason?
But you might not go on the when you are going to trial, especially for a homeowner who has limited resources. You focus your defenses based on the defenses that are going to most likely win for you. At that time, that was a slam dunk case. You don't need to spend a lot of money doing a lot of other discovery and litigation to win on that issue. If you know now that you're not going to win on that issue, it changes your trial strategy, how you're going forward. We can prepare our trial strategy based on the law before us at the time. When it changes later on, you have materially altered the decision-making process leading up to that trial.
Would it change your trial strategy? Now it's the past monies plus the pre 5-year money, so now it's at $76,000. So what's the trial strategy?
You could decide you're going to challenge them on standing. You could decide you're going to challenge them on the amount of payments that they're declaring, whether or not there was actual defaults in the case. There's a lot of things that you can challenge now that you decide I'm not going to challenge those because the easy money, the easy time, rather than me spending $20,000, $30,000, $40,000 on my litigation time on these other issues. This is, and I just want to note that the Strum case, that's exactly what they did. They remanded not for a judgment, but for a new trial.
All right, thank you, sir.
Thank you.
All right, I gave your counsel for the appellee a little bit more time, so if you need
Okay.
a little
Thank-
extra time,
thank
I'll
you.
give it to you as well.
Okay, so I just heard, so we asserted some defenses at the trial, but we didn't assert others that we had in our pocket. That's a trial tactic. That's something you can take a choice, you can make a choice to do that, but that should not be a reason why you remand for a new trial in this particular case, so they can come up with new defenses, or if defenses that they had that existed, but they chose not to raise, simply so that they can buy themselves some more time in this
In
house.
Strum, though, wasn't it at the end of the plaintiff's case in chief that they moved for a dismissal and the judge asked for briefing and then ruled? I mean, here you had a trial. Both sides put on their evidence. So to me, Strum is a significantly different scenario. I get it that I move to dismiss, the court buys it, and now, I walk away, I win. And then the appellate court says, no, you shouldn't have win. It's only fair then to send it back, I guess, to say, well, then put on your evidence and see where it goes.
Exactly.
And that's not what happened here.
Right. They had an opportunity to put on all their
They
evidence.
did. They put on whatever evidence they chose to put on.
And
I
if they
assume.
chose to keep some back for a later day or another bite at the apple that they thought they might get as they foresaw that all of this was going to happen and you were going to reverse, or you were going to reverse for me but send it back. I mean, that strategy is really kind of a
Yeah,
wing
but
and a prayer.
you don't use your closer when it's a tie game.
Right. Well,
I have no idea what that has to do with anything. I'm just trying to come
Or if that's even right.
some people do bring in the closer when it's a tie game.
trying to
because they're
get the
confident-
baseball analogy
They're confident
here
in the bottom of
somewhere.
the ninth that their team will
Okay.
hit the winning run. But I will say that Strum is definitely instructive because what they found in Strum, when this was only less than a month ago, it said, we reject the argument that the paragraph 22 notice of default can include only amounts that accrued within 5 years. We know that. We know that. Everybody in this room agrees with that. Accordingly, the Strum's argument that their default notice did not substantially comply with paragraph 22 also fails, and the trial court erred in entering a final judgment of dismissal. So that's where we are in line with Strum, because that's what happened here. Clearly, it's not a paragraph 22 issue. Now, let me touch on a couple things. Judge Edwards, you hit it right on the head. I couldn't write faster than you were saying it. 57105 has nothing to do with two parties to a contract. All it says is if a contract has a prevailing party fee provision that goes one way and the other side prevails, the other side can use the statute to reverse that prevailing party provision. That's not what we have going on here. What he wants to do is equate that. But you hit it on the head when you have the party's right to contract. We have a contract that says if you're in default, then if I have to...
Let me ask this. Let's assume you have two sets of fees. You've got the fees that the bank incurred in paying their own lawyers.
Right.
And then you've got an award of fees to the other, to the opposing side. Under your argument, can the bank recoup both of those fees?
We've never had a situation where the bank tried to recoup fees they paid out to an opposing party,
That they were ordered to pay.
that they were ordered to pay. So I don't have an answer, and I don't really think we're given advisory opinions here, and I don't want to speculate. Certainly,
Well,
unless you
I'm
want me
just
to.
trying to take, I'm trying to take your argument and extend it.
Right, to its
You know-
extreme. I get it. That would be the most extreme as far as sending the borrower a bill for my attorney's fee, for the fees that he incurred that I had to pay, and then try to just get them right back. I don't know the answer, Your Honor, and I guess until a case comes across where...
Seems like it should be no.
It seems like it, but I represent a lot of banks. I don't want to be on record that I thought, but again,
I'll give it more thought.
It'd be a tough one for me to argue, and I don't think any good bank lawyer would be up here appealing if in the event a trial judge ruled against us on that. But I don't know. I don't speak for everybody. I don't speak for all the banks. But in this particular
Would your
case...
position be that in terms of the paragraph 22 letter, that it wouldn't invalidate it?
If it was included in it. Again, we're talking about whether or not it's a condition precedent that fails. And if the court wants to equate that there is just so much wrong in the amount that's in that letter, that it's just horribly incorrect, that fails a condition precedent, I can see the court making that decision. But we don't have that set of facts here. We have one $10,000 amount.
But didn't the trial court say that's egregious?
Yeah,
that
the
we
trial
think-
judge said it, but it was based on a misconception of the law, number one, because she didn't read the contract well enough to know that we have that right. And Judge Edwards, I took the time, I have to take exception. There is no testimony by actually Ms. Lee that there was a first lawsuit. Every time a first lawsuit's mentioned, it's Mr. Colombo mentioning it, whether it's in the form of a question or whether it's in the form of a discussion with opposing counsel or the judge.
Or the bank's witness at one, and again, I don't think this is a big deal. I agree with Judge Lambert. We're talking about stuff that doesn't matter. 120, 121, your bank's witness is, well, that could be for foreclosure and court
I'm right there
costs
with
and
you.
all the rest of that, so.
My book's open to 121. I got it. And what I was going to tell you is it starts on page 119 of the transcript, and Mr. Colombo says, so we're dealing with the first lawsuit? That's how the lawyer throws it in there. And the witness says, we're dealing with payments from 2010. She doesn't concede there was a lawsuit. But he continues and he persists. And on 121, he starts to ask her about the line items. And by 122, he says, okay, encompassed in that $86,000 is $10,000 in attorney's fees, costs, process server fees, etc., and my client says correct. That's it. That's the sum and substance of the testimony of the first lawsuit. And that's why I say there was
Back
no...
at page 81 and page 84, and your time's out, so you're going to have to do it later, take a look. Ms. Lee says, you know, there came a time when I got sued, there was a foreclosure case, and it was dismissed. But take a look and see, you know, like I said, the red light's flashing, so we can have this conversation later, I guess. But-
Well, it says it went, and it got dismissed, and Ms. Macias objects.
Oh, go ahead.
And-
He's giving you time to talk about this. Go
So
ahead.
it says, so the question was, from their lawyer, at some point, you contacted me to help you out with that first case. That's correct. Question, and we went to trial and the case was dismissed. And then there's an objection, Your Honor, and then there's an entire colloquy between the lawyers and the judge about that.
Okay.
Lastly, I will tell you on the
No, that
57-105...
that was lastly.
Okay.
So-
There is a case post-1985, it's in my brief, 1993, where 57-105 existed and they still awarded fees because of the contract. We would ask that you reverse the trial judge's dismissal of this action or judgment in favor of the defendant, and because the foreclosure case in prima facie was
Thank you.
made,
Thank you, counsel.
you simply enter judgment for the plaintiff.
Thank you.
Thank you.